Republicans have doubted the constitutionality of the law. Few on either side have actually sat down and analyzed it, so let's do so now with constitutional law expert Jonathen Turly, professor of law at George Washington University. John, good evening.
Hi, Keith.
All right, there's something that Sheriff Dupnick just said that I want to get to, but give me the big picture first. What is the constitutional challenge to the whole thing?
Well, there's probably two grounds for challenge. One, probably the most important early challenge, could come from the Justice Department. There are various reports that the Justice Department is preparing to challenge this law. If that's the case, the most likely grounds will be on preemption, to say that the state is acting in an area that is occupied by federal law, and that they can't do that. They can't have their own immigration scheme. Now, that's not going to be as easy as it sounds. There's a case called Decanis, and it was a case about 1976, where the Supreme Court ruled that California could have this type of what's called concurrent jurisdiction. So what the Obama administration would have to be able to show, because the law itself does not rule out that type of concurrent jurisdiction. What they'd have to argue is that it is implied, that the scheme does not allow for this type of state law. And that's going to be an interesting fight. It's not as easy as people seem to suggest. It's going to be a close question, in my view. The second grounds, which is the one that I've been focusing on, is in fact reasonable suspicion. In my view, that is a perfectly horrible provision. I consider it to be perfectly un-American. It is correctly condemned as a sort of your papers, please provision. But the greatest challenge to reasonable suspicion provisions would be as applied, to wait for it to be enforced and then to show there's no way to do this except using improper racial criteria. You can't look at two people and say, I have reasonable suspicion of what you have or do not have in your wallet. But these lawsuits are likely to move before that. They're going to go, I think, very, very early, and so there'll be facial challenges. I happen to believe that this is an unconstitutional law, but it is going to be more difficult than people are suggesting in showing the unconstitutionality. Where
does the term reasonable suspicion currently fit into our laws and punitive actions against lawbreakers? Isn't that a stage before you go and ask a judge for a warrant?
Well, reasonable suspicion can be traced back to a case called Terry v. Ohio, where the Supreme Court allowed officers to do a pat-down of suspects if they had reasonable suspicion they were carrying a weapon for their own protection, and that obviously has some objective element to it. What you're doing in this case is to say you're looking at someone and saying these two people may be different in terms of whether they have correct papers on them. It's very hard to imagine how you could have an objective and constitutional basis for doing that type of thing.
Any citizen can sue any officer who does not enforce this law. I'm paraphrasing the sheriff there. Is that constitutional?
Well, it is probably constitutional for the state to say it. In my view, it's a perfectly ridiculous provision. It is so subjective, I can't imagine how a court is going to deal with it. It talks about suing people for, quote, policies that don't allow, quote, the full enforcement, close quote, of these laws. That is so riddled with subjectivity, it's perfectly maddening. But yes, this sheriff is correct. He is, when he says he's damned if he does and damned if he doesn't, that pretty much means you're damned.
Yeah, last one, and speaking of the damned, Duncan D. Hunter, the congressman, Hunter the Younger in California, that is what he wants, throwing children out who were born in this country. That is as ridiculous as it sounds, right? That's the 14th Amendment sort of covers that?
Well, first you get over the 14th Amendment, which talks about all persons born or naturalized in the United States. You also have to get by the Wong Kim Ark decision, which was about 1898, when the Supreme Court said that being born in this country makes you a citizen. That's a lot of water to haul, but I wouldn't bet on them. And this may make for good press, it may good for good rhetoric, but it doesn't make for good law.
Nice to see Congressman Hunter living up to the family tradition on that. Jonathen Turly of George Washington University. Thank you, John.
Thank you, Keith.